It was a great speech. It was a great speech.
It was, without question, if it was regarding the intent of using deadly force. But unfortunately, for brother counsel, that's not the elements of the crime. So the elements in this crime are make an assault with a dangerous weapon, but without intending to commit the crime of murder or inflict great bodily harm less than the crime of murder. So the weapon that was used in this scenario was a firearm. It was recovered by one of the officers. The testimony by the OIC today was that this firearm was recovered from the defendant's bedroom. The testimony today reflects that this weapon was used and aimed at the face of the victim. And the victim stated that he felt in fear. He panicked. He had to leave the situation. And that's what he did. Nothing on the record indicates a self-defense kind of claim where the victim approached the defendant with a weapon. He stated he wasn't armed. He had no knife, nothing. So I believe without question, probable cause, the standard of probable cause has been met in regards to these two elements, and we're gonna move to bind over on these two charges.
Thank you, Judge.
Go
ahead, I'll give you a shot.
I think the important thing to bring out is this goes to an affirmative defense that my client has. It's not necessarily we're going through the elements of it. We're talking about an affirmative defense. In the case law that I cited, People versus Robert Redden from 2010, published case of the Court of Appeals, allows you to raise a affirmative defense at preliminary exam. Typically, affirmative defense is going to be raised at trial. I know that. But that case specifically says you can do so. And in doing so, you can consider the credibility of the witness and whether or not it's reasonable for my client to feel threatened by this individual. You heard the facts, and I'm not going to repeat all the facts of the relationship. As I relate to the gun, that's the gun that's alleged to be used. That's not the gun that was identified by the witness. Again, going to his credibility of whether or not this crime really was committed. And what they say is this: if the affirmative defense has the issue, if the elements of the affirmative defense are met, this court can find that probable cause that a crime occurred did not happen. Because that's one of the things, whether he committed a crime and by probable cause, the elements of the crime have been present. So for those are the reasons why I think it's appropriate for you to quash bind over in this particular case.
I'll be very, very brief, I promise. I don't know what the affirmative defense is for. This victim went to the home of his father to show his father his newborn child. He didn't go there with a gun. He knocked on the door, he left. They didn't want him, he left. That's all that happened here. It's a sad case that a brother is pulling out a gun and aiming it at his brother for wanting to, his older brother show the family his newborn child. I think this is a very, very sad case. And it's sad to see that it happened. And we're still moving to bind over because the elements of the crimes have been met. Thank you.
Thank you both. The trier of fact. The testimony was that there was more than pointing a gun. There was get to stepping while you still can. That's a threat. And I'm a huge stand your ground, all that, but you don't open your door and point a gun at somebody. There's got to be something to precipitate it. If you ask them to leave and they refuse, if they make threatening gestures, whole different ballgame. The testimony today was there was no conversation. He was not asked to leave. The gun came out and get to stepping. This is a trier of fact issue. So I'm going to send it downtown. Your next court date is going to be February 14th at 9 a.m.
February 14th?
14th. Yep. 9 a.m. Bond will be continued once I hear something quick. Bond will be continued. Wish you luck downtown, sir.
You want to, just one last thing, those two exhibits, will they go with it?
I don't know how we're going to do that because, yeah, we don't.
The record marks those two exhibits, the video that dealt with that short interview with the brother regarding the description of the guns, as well as the,
yeah.
Thank you, I appreciate it.
Yeah, we can do that. Right, picture of the gun, just put in the notes that images were shown and admitted. Which one are you gonna do next, Mr. Mohammed?
I think Michelle Japanga, can I just go check?
Yeah, we've got her on Zoom. She's been here for quite a while. Gentlemen, you don't have to go far, but you gotta get out of here. Good luck, Don.
I'm sorry.
Good luck, Don.
I still have one more, Your Honor. Hopefully, he's not gonna pull my deal now. No, I'm joking. I'm
Mr.
teasing.
Mullin, I was informed that the exhibits are for this exam only, so when you go downtown, we'll probably be your
Oh, look, no problem. It's just, I'll file a motion to quash find over. I want to use that. You can only use the lower record.
Shannon.
As long as they're not part of this record, that's all that.
I can't do that, I don't have video, I can't do anything of it, only thing I do is I
Hold on, hold on,
transcribe
turn
it
yourself
after.
in.
No, that's all I need.
No.
I'll make the rest of the
Much
argument.
money and he hadn't done anything that was supposed to be corporation wants.
So you just came in today?
Yes, yes.
Okay.
And Al saw him this morning.
Okay.
Some morning sent it to me.
Good.
And once he's done, with all the information, he's going to search over to the commission. They have sheltered for him.
Really?
Yes. It's intended.
Yeah,
So my thing was
it's
checking
shelter
with you.
now?
Yeah,
Yeah. do
my
it.
was check with you.
Do it.
To see if we can, I can drop him off, take,
Sure. I don't think you should go alone.
huh? Yeah, I'll take this thing.
Yeah, yeah.
Okay.
Yeah, take him. Great.
Good.
Perfect.
Just wanted to clear it out, check.
Yeah,
I'll
no,
let
we
Mariah
did-
know it's about.
We just build goodwill with him. Now maybe we can close our files out with the community service.
Yeah.
Yeah,
Just wanted to make sure
Yeah, be
everything
careful.
was good.
Yeah, thank you. Yeah. Yeah. Wise guy. It's the black shirt. Yeah. All right, gentlemen, appearances for the people versus Michelle Japanga.
Good afternoon, Your Honor, Mohammed on behalf of the people, PA 6771.
Good afternoon, Judge Oakley. Good afternoon to your staff, Neighborhood Defender Service. Carrie Martin, P84592. I appear on behalf of Miss Michelle Japanga, who appears by Zoom. Ms. Japanga, state your full name.
Michelle Renee Devon.
Thank you, ma'am. She's still in treatment, I assume?
Your Honor, I had Ms. Japanga Zoom in today because right before I got a call from her around 11:30 and from her boyfriend, actually first from her boyfriend, that she had a seizure. So she's an epileptic and you had previously granted her permission to appear by Zoom
Right.
because of her epilepsy. She cannot drive. She had another seizure just today. Heard it from her as well. I didn't want to jeopardize her health in any way. And I had also heard from Detective Rice that an officer who I believe to be a necessary witness in this exam, that would be former Officer Kilgore of formerly of Romulus PD, is not present. So I am, for those and other reasons, if you'd like me to put them on the record, asking for a dismissal.
Is that a no? She's not in treatment?
She's not in treatment.
Okay, all right. Yeah, you're gonna have to give me more than she's had a seizure and they've got one missing witness. What other reasons do I have for dismissal?
Well, Your Honor, the missing witness is the officer who, in this incident, which was November 2021, who first approached Ms. Japanga, found her overdose. That's a critical issue for exam because that would, under the statute, show you that would make it that she had not committed this offense. Now, the only officer that we have is an officer who arrived later after this had occurred. In addition, we don't have body cam. And I had Judge Martin sign a discovery order requiring that they produce body cam depicting the interactions with Ms. Japanga. I was provided some other forms of digital discovery, but was informed, Mr. Mohammed showed me a communication from the OIC. I'm not sure whether it was Detective Rice or the previous OIC on this case, that body cam no longer existed.
All right, so the initial contact between her and was it Kilgore?
Kilgore.
That we don't have that video.
We don't have that video
Okay.
and we don't have Kilgore.
Okay, okay. All right, response?
Judge, we did, after that discovery order, from what I recall, my computer is down at the moment, but I do recall, us sending some digital discovery that we got. And as Mr. Martin, disclosed, some stuff just didn't last over time. I think this is a couple years back. We are ready to move forward today. We do have Officer Dorsey. I understand, Ms. Japanga suffered, seizure by regards to that. But we are prepared to move forward today. We are missing one officer that does play an important role, and so we would request a help in part in regards to that officer.
Okay.
And
Is there, hold on a minute. Am I safe to assume that you don't have any civilian witnesses, just law
No,
enforcement?
police officers.
All right. So number one, she just had a seizure. Number two, you want Kilgore. I'm assuming you don't know if you can get him or not.
Yeah.
Do we know?
He works down in Auburn Hills, where we get a hold of him. This subpoena came in late, so he is available.
Okay.
We weren't able at the time to get him
Okay.
for this day.
All right.
And just for the record.
So hold on. I don't want to start it and finish it later. That's selfishly, it's just rougher on me. I also think that it's not probably the most compassionate way to handle it for Mr. Panga. I'm inclined to adjourn.
Your Honor, I would respectfully renew a request for dismissal, not just because of the missing witness, but because of what I'm saying is a discovery violation that will prejudice Ms. Japanga if this case were to go forward.
But if I understand correctly, you've got everything they've got. They just don't have what you want.
Well, what we have is a concession from the people that this body cam footage previously existed, and they allowed it to be erased, destroyed. That is a Youngblood violation. That's a due process violation. That is, they once had access, control of possibly exculpatory evidence, and they failed to preserve that evidence.
Yeah, but I also, and I'll give you a chance to argue it, but I also think there's got to be a bad faith before the result is a dismissal.
Youngblood does require bad faith. Bad faith can arise from blanketly, maintaining a system that erases discovery, including on pending cases. I mean, this isn't just, our old closed cases. We can say, it was just a technology failure. But at the end of the day, if you have a police department that is knowingly or that knows that footage from pending cases is getting erased and destroyed, I would argue that's enough for bad faith for Youngblood. And even if you don't need Youngblood, I would argue it's a Brady violation, which doesn't require bad faith, where you had possibly exculpatory or at least impeachment evidence that was in the possession of the people that has not been provided.
All right, so let me ask you this. What do you think the video is going to show that helps her?
I think the video would show that the police officers who responded were responding to what appeared to be a drug overdose and what I actually believe was a drug overdose.
Right. That
under the statute, I mean, I've got it right here. Basically, all the sections of the Controlled Substance Act, including the one she's charged under, which is 333-7403, contain a subsection 3, which states that an individual who requires medical assistance and is presented for assistance by another individual, if he or she is incapacitated because of a drug overdose or other perceived medical emergency arising from the use of controlled substance, and possessed an amount sufficient only for personal use, and this evidence of the violation is obtained as a result of the individual seeking or being presented for medical assistance, that individual is not in violation of the section.
Okay.
Now, I would say that—
Hold on, I'm with you. So is it the people's position that she was not suffering effects of an overdose at the time of the interaction?
I think that is the people's position, is that there was a response for a 911 call. The officers responded, they made contact with the defendant. And in plain view, they did observe drugs, which were the suspected cocaine.
But she was conscious, she was interacting.
She was conscious, and it was her own words that it was cocaine.
If I could.
And
respond.
Yeah. I just want to make sure I know what their
The
position is.
nature of the 911 call was an unconscious female.
Okay.
When, according to the report, when Officer Kilgore responded, Ms. Japenga was unconscious. He performed a sternum rub on her. And though that did arise her, she was later, nodding off again.
Right.
And Judge, just for the record, I'm pretty sure the person who did that 911 call was her friend. And I don't know if that helps.
I don't think that matters under the statute.
I just want to make sure I'm disclosing.
I think the determinative factor in the statute is her condition at the time of the initial interaction. Would we all agree on that?
Yeah.
Okay.
I'm with you.
Okay. I'm not going to dismiss it at this point. Here's why. If Kilgore's testimony is all of what you just told me, I think then that's the argument.
Yes.
She was in the midst of an overdose at the initial interaction.
Yes.
Which then I think triggers subsection 3.
Yes.
I don't need a body cam. If he says, no, I got there, she was talking, it was fine, blah, 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 then you can renew your motion because, yeah, I think at that point, the body cam could impeach that testimony.
Well, for purposes of today's argument, given that the people did not subpoena Officer Kilgore, would you entertain looking at the reports in which Officer Kilgore does state that he found Ms. Japenga unconscious?
And I'm going to object to that misrepresentation Mr. Carey is making to the court and for the record. Subpoenas were sent weeks in advance.
Oh, no, don't even go there because I'm not think he's trying to. I don't think he's trying to paint you in a bad light. He's saying we don't have the cop, but we've got his record. Can we just go forward with his report? Any objection to that? I mean, I'm okay with an adjournment if you want to get Kilgore here, but if you want to save the time and just go on his reports, from what Mr. Carey just told me, the reports make the argument. I mean, I haven't seen the reports, obviously.
Yes, and I would need to grab my computer and pull them up, but I can do it in about 30 seconds.
I feel strongly both ways, so.
So, Officer Kilgore, it does state that he performed a sternum rub to wake Miss Michelle Japenga. Japenga woke up and when asked what she had taken, and that's when she made the statement that it was possibly cocaine. And that's a representation I want to make to the court.
Okay.
And I'll, live by your decision.
Well, I think we can all agree if he's doing the sternum rub, it must be because she was non-responsive when he first approached her.
Agreed.
I'm dismissing it.
Thank you, Judge.
And you guys can build the record. You can take the dismissal because the discovery violation, because of section 3. I think we could have a full-blown exam. I'm going to be the same place.
Yeah, I think section 3 doesn't apply.
All right.
Thank you.
Okay. Ms. Japenga,
Yes.
you're all set. Case dismissed.
I'll call her.
I'm going to write it up as dismissed after exam. Just because I don't think it matters too much, but that's why I'm going to write it up.
Works for me, Judge. Thank you very much.
Good luck, ma'am.
Your Honor, thank you very much.
Thanks, guys.